Hello, my name is Jed Strong and I'm the owner and founder of Strong Law. Today I want to talk to you about ORS 2080 cases. And they are it's a special statute specifically for small auto accident cases in Oregon. And it comes from the ORS statute 20.080. And it's one of my favorite ways to handle a small injury case because it really forces the insurance carrier to treat a small case fairly. And so what do I mean by that? Most of the time, auto accident attorneys work off of what's called a contingency fee. For example, our firm and the standard is typically 33% if the case settles before you file a lawsuit, and 40% if the case settles after you file a lawsuit or if you take that case through trial. Now, the problem though is that lawsuits can be extremely expensive and add a lot more complexity and time to a case. Not only do you have to pay the increased attorney's fee, but also there's a lot of costs involved in lawsuits. You have to pay the court for filing a lawsuit. You have to pay for depositions. You have to pay a lot for expert witnesses, for doctors to come in and testify about the injuries. They can all get very, very expensive. And insurance companies know this. And so they know that if the case is a low value case, if it's a relatively small claim with relatively small injuries, then it's probably not worth it to file a lawsuit because of all of these additional costs that you're just gonna have to pay to other people, and that money actually doesn't go to the injured party. So what insurance companies often like to do is they like to strong arm these small cases and offer a small amount. So say the case is worth $7,000. Well, they'll offer $5,000 because they know that if the person accepts the $5,000, they'll end up with the same amount in their pocket as if they went to trial and got $7,000 because of all those additional costs and fees. So it's really unfair to people who are injured in small accident cases. Well, ORS 2080 changes this by kind of flipping the tables on the insurance companies. And so what a 2080 demand or an ORS 2080 case does is when you send a demand to the insurance company, you tell them, hey, we're demanding this as a 2080 case. Now, the downside is that you can only ask for up to $10,000. So if you have a large case, you can't use this process, but if your case is worth $10,000 or less, it really makes sense to use it, and you have to go through the special process to make sure that it complies with the statute. But if your demand complies with the statute, and then you can present this 2080 demand. And what it does is it forces the insurance company to give you their best offer. So let's take this example again of a case that's worth $7,000. If the insurance company plays its game and tries to offer you $5,000, well, in that situation, what you can do is you can actually go ahead and file a lawsuit. Even though it's quite a bit more expensive, what it does is it changes the way that the attorney is compensated. So rather than working off of a contingency fee of 33 or 40% on the case, the case switches to an hourly basis. So the attorney would then bill by the hour rather than a percentage of the fee of the case. And that can get really expensive really fast. For example, my firm typically charges $375 an hour working on hourly matters, including these 2080 cases. And so by the time you get through even a small lawsuit, you're looking at somewhere around $15,000 of attorney's fees billed at that hourly basis. And what the 2080 demand does is it says that if you go to an arbitration in this scenario, if you go to an arbitration and you win and the arbitrator awards you more money than the insurance company offered, then the insurance company has to pay whatever the award is, plus they have to pay those attorney's fees billed at an hourly basis. So in our scenario, the case is worth $7,000. The insurance company offers $5,000. In that situation, you would take the case, you'd file a lawsuit, you'd go through the whole process of an arbitration. The insurance and the arbitrator would award $7,000, which is the value of the case. So now the insurance company has to pay the $7,000, and since they originally offered $5,000 and you got $7,000, so you beat their offer, they then have to pay the $15,000 of attorney's fees on top of the $7,000 amount. So it makes it much more stringent for the insurance companies, and they have to go in there and they have to fairly assess the case, because if they try to lowball an offer, they're going to get slapped on the back end by having to pay the fair value of the case plus all of the attorney's fees. So if you send, but you can only do that if you send the demand through the 2080 process, and you jump through the different hoops in the 2080 statute to make sure that the demand qualifies. And so that causes insurance companies to treat small cases in a fair manner, because there's that risk that they now suffer of, or the risk that they face of suffering a much higher award on a small case. I mean, I can't tell you how many cases that we've had that an insurance company gives a terrible offer, and then we turn around and file a 2080 demand, we file a lawsuit based on the 2080 demand, and the insurance carrier has to pay 3, 4, 5 times more than they offered at the end of the day. So it really forces the insurance companies to be fair. Now, that said, there is some risk and reward with these 2080 demands. So let's take our example of a $7,000 case and a $5,000 offer. So let me just do some quick math here. So if you take that regular case at $5,000 and you settle that case, it would be settled on a contingency fee, because that's typically how these cases begin, is through a contingency fee. So it would be a third. So there'd be $1,600 of attorney's fees. And if you settle for $5,000, $1,600 of attorney's fees, and that would leave about $3,300 for the client, for the pain and suffering. So your ultimate take home would be $3,300. Now, if you go through the litigation process and you get that $7,000, well, that full $7,000 is going to the injured party, because the attorney's fees are paid separately. They're not paid out of the award anymore. They're paid on an hourly basis by the at-fault insurance company. So it would more than double the amount that the injured client would get in that scenario. But it's not all sunshine, because let's say that the insurance company offers $5,000 and the case is really only worth $4,000. Well, in that situation, if the arbitrator awarded only $4,000 after you filed the lawsuit, then the insurance company offered more than you got in litigation. Well, the fees at that point would be owed by the injured party on an hourly basis. And again, those fees are $15,000, and you only got $4,000 in the case. So you're not going to see any money out of that. Now, most firms that I know, well, at least my firm does. I don't know how other firms deal with it, but we never force our client to pay that the remaining $9,000 on the bill, because that's just not fair. But in that scenario, the client would not receive anything, because all of the settlement proceeds would be going to pay the fees for the attorney to litigate that case. So when you do the 2080 demand, it forces the insurance company to give you their best offer, but then you have to really take a look at the case and say, can we beat their offer? Does it make sense? Like, what is the chance that we will get a better award from an arbitrator than what the insurance company is offering? And if you're not confident that you're going to beat that offer, then it's a good idea to accept the offer, because it's probably a fair offer to begin with, and you should always accept fair offers. But B, there's that risk that the injured party does not walk away with anything, because it all goes to the attorney's fees. Conversely, again, if it's a bad offer from the insurance company and you are confident that you're going to win, and you go to arbitration and you get a better award than the offer from the insurance company, the client walks away with a lot more money, because the attorney's fees are paid by the at-fault insurance company rather than through the settlement or the award proceeds. So that's a summary of a 2080 demand. I think it's a great tool on small cases to make sure that insurance companies are fair, and it helps resolve a lot of cases. And then when the insurance company doesn't play fairly, then it really makes it profitable for the client, and really punishes the insurance company for being unfair from the outset. So if you have any additional questions on that, please feel free, reach out to us and discuss the nuances of your case. But if you have a small case, I highly recommend the 2080 process.